Hi, welcome to the House Judiciary Committee this Tuesday morning, May 6th. And we're going to start with H41, which I anticipate will be on the notice calendar back from the Senate. I thought it was going to be on the notice calendar today, but apparently it takes an extra day to get to us. But I anticipate it will be on the floor this week, and we need to look at their amendment and decide if we are going to concur or if we're going to have further amendment, or if we're going to ask for a conference committee. So as a heads up, Tom Burdett is working with this and with the folks downstairs. So I anticipate we're going to be pushing for the first, which is a concur, if I'm right, but we'll see. Let's see. We'll have to see. I'm open. So, yes.
Are we going all the way back to the start of the year where this has been down in the Senate that long?
I don't know when we passed it out, but yeah, it's taken a bit, so.
Yes, they had stuff on their agenda on the calendar that already they had to take care of before they put this up.
Yeah, it was after a crossover, and they've actually moved a few things that have gone directly to the governor. H118, H21, S3 are three bills that they passed out and didn't send back to us. In other words, they just found favorable. So
I'm just
moving our things along pretty well. So
I just thought that this was already taken care of. That's kind of naive for this.
no. So over to you, Ben, to explain how this has changed from when we shipped it to our friends in the.
Do you want me to share my screen or, okay. So for the record, Ben Novogrodsky from the Office of Legislative Counsel. Before the committee is the Senate proposal of amendment to H41, which from a words on the page perspective isn't very large, but is notable in other ways. So for instance, you'll notice the key difference really is the change in subsection B. So right now, as the Senate has proposed, it reads that no person shall violate subsection A of this section for the purpose of concealing a crime or avoiding apprehension, prosecution, or conviction of a crime. Subsection A states that no person shall knowingly, without legal authorization, intentionally burn, mutilate, disfigure, dismember, or destroy the dead body of a person. A and B, or B is different than the as passed by House version, because that used to really outline the specific actions that were criminalized. So for instance, shall not intentionally bury, transport, hide, conceal, burn, mutilate, disfigure, dismember, or destroy for the purpose of concealing a crime or avoiding apprehension. They changed it, so it's now just a violation of subsection A constitute with the purpose of concealing a crime or avoiding apprehension creates a violation of B. Now, the reasons underlying that change, and there was a lot of testimony and an issue that the House dealt with to a degree when it was before this committee, was the concern over prosecuting mothers that have that may have hid a child or a fetus after birth for fear of retribution. That's at least one example. And there was testimony about how these statutes are being used to prosecute women in other American jurisdictions, excuse me. So this change was done to try and bolster or rather mitigate against that concern. So because if you remember, if you turn to page 3, or rather page 2, the bottom of page 2, section 2, which is the current statute under Title 18, that public health statute about a burial permit that's necessary if you're going to bury or transport or remove the dead body. That covers the situations that were raised that women are being prosecuted for in other jurisdictions, that sort of hiding without authorization, so to speak. And what this committee did prior is remove the criminal aspect to this and made it a fine And what the Senate did is refine that further to clarify what I believe was also the House's intent to make sure it was a civil penalty. So we're just changing the wording from fine to subject to a civil penalty. So the effect of all of that is that if there were a circumstance where there was a person who hit a body after without authorization, as you would need, it's no longer a criminal offense. It's only subject to a civil penalty. And so this language really reaffirms that. And I can get into the details of the case law that explains why, if the committee is so interested. But there's case about the difference between a person and fetal remains are something that's handled within Title 18. And that's why moving all of this sort of nicely under the Title 18 umbrella keeps that consistency, as opposed to creating a potential situation where you're facing a prosecution for a crime for moving or burying a dead body without permission.
Is that a grammar error in 16, line 16? Should it be to do so or so to? It sounds funny.
It's current law, so
It's current law.
whatever the grammar was back when.
Line 16.
It's clunky, but it works.
So to do.
Huh?
It's
It's clunky, but it
current
works.
law.
Very funky, all right.
Oh, yeah. Maybe something for me to mark off on the technical corrections bill for next year. It always amazes me. Like, I don't know how many times I've read through this, the editors have read through it, and you still miss these things, you know?
Yeah.
So I appreciate the assistance. Sarah Oliver rubs it all over, yeah.
That's Angela's forte.
Yeah.
Right.
He just came up in case you missed it.
Ian,
Can you just walk us through a little bit more how the distinction in A and B that the Senate made
Sure.
helps to sort of like accomplish the concern that they had?
Right. So in the Senate, the issue was raised that A and B, as they left the House, could they be construed to apply to a person who has a miscarriage or a stillbirth and does not dispose of the fetal remains in accordance with Title 18?
Yeah.
Right? So current law establishes under Title 18 that you need a burial permit to entomb, transport, or bury a dead body, right? A person who violates that is subject to a term of imprisonment of 5 years or a fine of not more than $1,000. And those are codified. Both those statutes are codified in Title 18, Chapter 107, Subchapter 1. A separate Subchapter 2 in Title 18 regulates fetal deaths. So fetal death means a death prior to the complete expulsion or extraction from the mother of a product of conception. The death is indicated by the fact that after such separation, the fetus does not breathe or show any other evidence of life, such as a beating heart, pulsation of the umbilical cord, or definite movement of voluntary muscles. So, since those things are in Title 18 and there is a distinction between a person and fetal remain, we're keeping that distinction valid, or as clear as possible, rather, since it's already been recognized in case law, not necessarily adjudicated because it was dicta in case law. And for those that don't understand what dicta it means basically the court discussed a subject without deciding it. And so they said, we don't need to just decide whether this was a fetus or a human because both apply in the situation. And so what we're doing is essentially making it so that distinction as recognized in Title 18 remains. So thus, if a fetal death occurs and a person disposes of the fetal remains without the permit, that is handled nicely in Title 18 because fetal remains and the remains of a person are handled the same way. And that is recognized in State v. Chambers. 144 VT 234, it's a 1984 case where someone was charged with burying the dead body of his stillborn daughter without a permit. The defendant challenged the charge, alleging that the state had to show that the buried dead body was a person and not a fetal death, and the court rejected that argument. saying that it's without merit, subchapters 1 and 2 of chapter 107 differentiate between dead persons and fetal deaths. However, there's another portion of the law which deals with the disposition of fetal remains and required permits, which specifically states that the sections applicable to fetal remains are applied the same way as to dead bodies. Thus, for the purposes of 18 VSA 5211, which you'll see in section 2, it's irrelevant whether the buried body was a dead person or a fetal death, and they didn't have, so it was a non-issue. So they're saying that distinction remains, and it's a valid distinction. And so the reason why we removed the language from Title 13 is to try and keep that distinction
As clear as.
as clear as possible, so that we're dealing with a person in Title 13 and people that are, as this bill manages, the way that a dead body of a person is handled and treated, so we're not dealing with fetal remains.
Yeah.
Yes.
I think then the only, so I appreciate that, and I that makes sense to me now. The other, I guess now that I'm reading it with the language as proposed, A and B, it's like, I think my question is, so like when you have like a criminal charge, like gross negligent operation with death resulting, you don't have like a subsection underneath that says, also you'll be in violation of this statute if you are doing it to avoid apprehension or prosecution or commission of a crime.
Mhm.
And it almost like reads the exact same, like, it's just like indicating that this is also a crime if you also did it to avoid apprehension.
Well, it's because in this statute, the scheme is that it has an elevated penalty.
Oh, and that's the only
For
reason
B.
that we're, okay.
Yeah, so, and I didn't mention that because the penalties didn't change.
Oh, okay.
But if you'll see subsection D, someone that violates B and C, so B was originally broken down into B1 and B2.
Yeah.
What this does is that it separates B and C into separate subsections that are both held to that elevated sanction of 15, not more than 15 years in prison and fine not more than $10,000 or both, as opposed to a violation of A, which is 5 years and fine not more than 1,000 or both.
I just needed the reminder.
Yeah.
Thank you.
And so just to kind of put as much of a pin in this as possible, that under the language of this amendment, the new crime in section 1 applies to abuse of a dead body of a person and does not apply to fetal remains. Improper disposal of fetal remains would be continued to be subjected to the provisions of 18 VSA 5211. So maybe I gave you a little bit more information than you needed, but ultimately that's the conclusion of why this was done.
Yeah, I really appreciate it. Thank you.
Tom?
Yeah, just, I sat in on the Senate a little bit when they were doing this and just want to thank the work that Ben did, the Senate did, that Jessica did, as far as coming to where we are.
And Michelle.
And Michelle,
Count,
I'm
because
sorry.
she was instrumental in getting this done too. Yeah.
Yeah, it was just a group effort, I guess you could say, to come to this conclusion. And maybe when Ben is done, maybe Jessica can just sit down and give me, her opinion on it and where Planned Parenthood is at. But one thing that, I know we talked about it earlier, Ben, about possibly changing the title of this law. And if you could just touch on why it might not be a good idea at this time.
Sure.
It's something that could possibly be addressed down the road, but.
Yeah. So the prospect of creating a short title to refer to a bill is something that can be done. Generally, it's not. And generally, there's a policy reason to inform why or why not you might want a short title. So, for instance, an example of one is like the Clean Water Act. It can be referred to as a Clean Water Act because that was a short title provision in it, but it wasn't, the title of the actual bill as it passed through was not that. In this context, to create a short title, there's a pretty big policy consideration that I want to present to the committee, and it's the fact that this is an ongoing criminal case right now. So if the committee decided to create a short title in honoring the name of the victim, It could be seen as almost a legislative adjudication of guilt prior to the court going through its process. And so there are potential really serious consequences for the case at that point if it could potentially impugn a juror's objectivity. The defense attorney might have some avenues and levers to pull as far as, if it did potentially affect the outcome of the case to move for a mistrial. So that's a really significant policy consideration to consider prior to engaging in any request for a short title. Now there's a potential that after the case is done and the appeal period has expired to maybe revisit the bill or the law and amend it at that point once the case is over. But right now, since it's ongoing, it's a policy consideration I wanted to flag for the committee.
Thank you.
Any other questions for me?
If you don't mind.
Yeah, if Jessica, are you available to?
Yeah. So, put you on the spot.
Good afternoon, everyone. It's been a minute since I've been here. Jessica Barquist. I'm the president of affairs for Planned Parenthood of Northern New England and the Planned Parenthood Vermont Action Fund. And I just want to start by really acknowledging the work of this bill and the intent. We understand how difficult and how important this legislation is for this family and for those involved. And that being said, we did have some concerns because we are seeing these abuse of a corpse laws being used in other states to really criminalize pregnancy complications or abortions. Post Dobbs, that was the decision that ended Roe, roughly 2% of the pregnancy criminalization cases have been on laws similar like this. So it was really important to us that we get this language right. And we worked really closely with Legislative Counsel and Representative Burdett and the Senate to come up with this version. And so Section 1, the language changes there, really streamline and clarify that what you're talking about is about like the cases that you heard and not about fetuses. And then where fetuses are represented in Title 18, that would be your Section 2 in this new bill. Really removing some of the criminal penalties there and actually strengthening that law to protect women who might have a miscarriage and want to bury it or whatever that case might be that could fall under a law like this. So we are extremely supportive of Section 2, and we are neutrally supportive of Section 1. We think it remedies our concerns, and we feel really good about where this bill landed and all the work that went into it.
Questions for Jessica? Not seen any. Appreciate it. Thank you. For reading.
Thank you.
Thank you for your work on this.
Yeah, of course.
All right, I think I understand where we want to go with this, which is taking a motion to concur with the bill as passed. Well, actually, wait, I take that back. I need actually the bill here before we do that. So in a couple of days, when it actually gets to the notice calendar, we will have this vote.
If we can remember.
Yeah, just in case something, well, nothing's going to change. This is what passed the Senate, but we still need to wait until we actually officially have received it from the Senate. But I have a motion to concur at that point. All right, so we have a couple minutes before our next, and I can kind of just give a real quick reason why we are going into labor law.
I know that sounded really weird after
this. That was.
It's like a meeting.
Oh my goodness. Oh, well, that's what I meant. So we're going to be looking at something, a bill called S-125, which is coming from the House General Committee. We are only looking at Section 5, which is on page 6 and 7. And the reason that we're looking at this is a request from Terry Parsons, who will be showing up to testify shortly. And the impact of that the bill could have on the judiciary, on the courts. So that's why we're doing this bill. And we should be seeing folks here very shortly, including Sophie, who's going to walk us through this.
We're looking at section 5.
Section 5 on page
Definitions?
6. Yep, just that one strikeout.
Managerial and not supervisory.
Correct. Cool. And genius. And the bigger picture of what that is, we'll get that from legislative council momentarily. And I would say let's just take a break, but everybody would leave. And I know legislative council, we only have her from 1:30 till 1:45. So we can go ahead and take a break, but just no, we only have, what you talking about?
Well, no, she's not here.
Well, we can just
Hang out.
keep.
I'm out of here.
So we could talk about what other things we want to look at if we finish all of our work.
411.
What's that? Of course, we'll look at 411 and see what's left in 411. I'll write.
That was very quick.
I'll make sure I write.
It's just like a dime.
I think I'll make sure I write that down in our list of things that we want to look at.
Justified homicide?
I don't think justified homicide, they're quite ready
Yeah.
yet, so. Let's see.
How about,
Let's see what we have. Oh, there's so many things here. I don't know if I can fit 411 in.
I get it.
I'm just kidding. I wrote it down.
how about H492?
What's that?
It's the animal bill that we tried to do.
It's
your
bill. It's your bill.
Well, it wasn't asked by anyone.
No,
The animal thing.
No, it's just Emily's bill this.
Yeah, you know that animal, this state's getting out of,
We're live.
am I saying something wrong?
No, not yet.
Not yet.
Yeah.
If anybody's paying attention, or if they're not, this animal cruelty stuff is getting really out of control.
We need to do that bill.
So before you people all jump all over me, think I'm gonna say something bad.
So H492 is that? That's the
Yeah.
animal cruelty bill, right?
Mm-hmm.
So we do that in conjunction with
the dog bite.
Dog bite?
Yeah, that's what I lobbied for last week.
Okay, and four. What is 223? Well, that's okay. All right.
Yeah, we have to revisit 223.
Uh,
You said it.
yeah.
I might have a funding source for,
Hearing that we may not have as much time the rest of this session for all these things, but maybe we can get some introductions.
victim.
All right, we have
victim
our
showing.
legislative council. Excellent.
Waiting for me.
Yeah, well, no, we just got done a little bit early, so we will go right into S25. Sophie, I think this is the first time in my 11 years here that you've been in front of me.
Yes.
It's very nice to have you. So I explained very briefly what we were looking at, and just to reiterate, we really are only looking at section 5 of S125. And I know it's just striking one word, but we want to understand the implications and what that really means. Not really our jurisdiction as far as labor law, but we do want to understand the impact potentially to the court systems as well. And we're going to weigh in with the host general. So thank you for being here. Over to you.
Pleasure to be here. So Sophie Zadatny for the Office of Legislative Counsel. I'm assuming you don't want me to put it up on the screen, as it's just that one word.
Yeah, I think we're fine.
Okay. I could fish my computer out and log in and all the rest of it. What Section 5 does is it would remove the exclusion for judiciary supervisors from the definition of employees who are able to organize and collectively bargain. So essentially, it would extend the ability to organize and collectively bargain to judiciary supervisors. The language that the definition of a supervisory employee under the Judiciary Employee Labor Relations Act is virtually identical to the language of a supervisory employee under the State Employees Labor Relations Act. And it's not that different to the language under the National Labor Relations Act. And I flag that because Vermont has gone in quite a different direction to the National Labor Relations Act. So the National Labor Relations Act covers private employers private employees that are involved in interstate commerce. And it leaves to the states the ability to legislate around public sector employees. So under the National Labor Relations Act, supervisors are excluded from the right to bargain. In Vermont, as I say, under the State Employees Labor Relations Act, they were initially excluded, but then in 1977, the legislature removed the exclusion of supervisors from the State Employees Labor Relations Act. The Judiciary Employee Labor Relations Act came along later, and under that act, they're currently excluded. So although the definitions are very similar across all three acts, they've been handled differently at the federal and the state level.
Yeah, Zach.
Sure, I just have a quick clarifying question. Sophie, thanks for being here. Should Proposition 3 pass, how does this interplay with it?
That is a very interesting question. Yes, so Proposition 3 would allow employees, doesn't define employees, just employees generally, to be able to organize and collectively bargain. Probably the way that would play out would be that if you had individuals that are currently excluded from bargaining under state law, they would then be in a position to, go to the Labor Relations Board or go to the courts and say, I have a constitutional right to organize and collectively bargain. And given that's a constitutional right, it would likely trump an exclusion that currently exists in state statute. I would anticipate there are going to be certain categories of employees that would be unable to organize, which I would say would be confidential employees and managerial, the very top level folks would not be allowed to. But, arguably, yes, judiciary supervisors or other currently excluded groups under any of the current state statutes that we have could say, I'm now given a constitutional right to do this.
Thank you.
So was any rationale given at the state level when these exclusions happened?
I don't know. I mean, I assume there must have been, but the allowing state supervisors to organize, as I say, was 1977. I haven't had a chance to go back and see if there's any sort of legislative history as to why that change was made.
And then it happened, I feel like our committee a few years ago looked at, it might have been state attorney being supervised.
Yeah, so there are under the State Employee Labor Relations Act, there are state deputies, attorneys are able to organize. So yeah, there are, I'm sure there've been numerous bills over the years for different categories that are currently excluded under different acts to seek to be covered.
And we tend to just deal with it sort of piecemeal as one group
Right.
asks rather than,
A comprehensive look.
yeah, okay.
So following up with Zach's question, it seems that even if we left supervisory in here, if they didn't make that change, this is something, assuming the Prop 3 passes, will probably be before this body again. It seems.
Right. I mean, so Proposition 3 will now go to the voters in November of 26. So again, I don't want to tell the General Assembly what to do, but it might be worth looking at the statutes in 27 to see if changes should be made to accommodate the fact that if assuming the voters approve the constitutional amendment, like how would we address that as a state moving forward?
So can you explain again why supervisor or manager should be treated differently?
So, I mean,
Why is it treated differently?
right. I mean, the notion is that organizing and negotiating contracts, you have management on one side of the table and you have labor on the other side of the table. So historically, like under the National Labor Relations Act, the notion is that the supervisors belong on the management side of the table. And again, Vermont went in a different direction with regard to the State Employees Labor Relations Act. And so supervisors, they have a much narrower view of it. So if you're a lower level supervisor where you may be supervising a handful of people, but you're not making big policy decisions, you're not developing the budget, you're not handling sort of big personnel decisions, then you would be allowed to organize. And again, we do have in Vermont, supervisors under the State Employees Labor Relations Act are able to organize. Typically, they're in their own unit. They're not in the same bargaining unit as the folks that they actually supervise. So you have a supervisory union. So it's just, a different approach, and Vermont has just taken a more expansive view in terms of, who should be able to organize and who shouldn't. And I would say at the national level, the National Labor Relations Board has also become more expansive in how they view supervisors and have tried to narrow the definition to allow more people that may hold the title of supervisor to be able to bargain. But in Vermont, it's a very fact-specific question, like what exactly does the individual in that particular position, what do they do, what are their job responsibilities, to make that determination as to which side of the table they should be on.
So I understand that initially, the employer gets to decide the labels of manager or supervisor, but can that be challenged?
Right.
How would that be challenged?
Right. So the statutes provide, who makes that determination. And then if someone disagrees with that determination, ultimately that goes to the Labor Relations Board, and they decide who should be in a unit and who should not, which specific positions should be included in a particular bargaining unit and which ones aren't. And again, there are labor relations decisions, which I know is mentioned in the memorandum. There's one that talks about, the analysis that the Vermont Labor Relations Board did, I guess in 2012, regarding individuals in the Department of Public Safety and whether or not police lieutenants should be considered supervisory or managerial. And so ultimately the Labor Relations Board will look at that. And again, it's a very fact-specific analysis that they'll do.
So is it fairly well understood what would what would be properly labeled a manager versus a supervisor, given that case law?
I would say it is for the State Employees Labor Relations Act. Again, wasn't able to find any decisions involving the Judiciary Employee Labor Relations Act or any Vermont Supreme Court decisions. So it hasn't been flushed out as far as on the side of the judiciary. But I would anticipate that the Labor Relations Board would look at its precedent under the State Employees Labor Relations Act and apply same principles when it's looking to analyze it under the Judiciary Employee Labor Relations Act.
Yeah.
Aaron, I think you said this and I just didn't quite follow, but does this change that we're looking at in S-125 actually bring Vermont more in line with national standards or most other states?
I would say it brings the Judiciary Employee Labor Relations Act in alignment with the State Employees Labor Relations Act. But again, and public sector employees it's determined by state law. So although the National Labor Relations Act excludes supervisors from bargaining, then they're not dealing with public sector employees. They're dealing with employees of private companies.
Okay. So it's more, I should be thinking more within the state and how it's bringing the judiciary employees on par with state employees as far as.
Yeah, I think I believe that's the argument behind
Okay.
for doing this.
Thank you.
Other questions? I don't see it. So thank you very much for your time. Appreciate it. So I'll go to Terry Carsone's next.
Terry's questions.
Good afternoon, everybody. Terry Carson, State Court Administrator, and I'm joined by Attorney Joe McNeil, who's a labor relations lawyer from Burlington who has worked very closely with the judiciary over the years in terms of contract negotiations. And I did submit two memoranda in conjunction with the testimony, and I said to me I would be happy to bring paper copies if people would prefer or like. They would like? Yeah. Okay, great. The first memo is in conjunction with testimony that Attorney McNeil and I originally gave to House General and Housing Committee. Then some new information came to light in the testimony surrounding that. So we have since submitted a supplemental memo. And I'll refer to both of them and try to briefly summarize for you so that I'm not throwing too much information at you at once. But as Sophie explained, we're here specifically with regard to Section 5 of S 125, which proposes to remove supervisory employees from the list of exempt employees that's enshrined in Vermont law. And currently in the judiciary, the exempt employees, as Sophie indicated, the demarcation typically is non-management and management. And along those lines, in the employee or in the statute regarding judiciary employees, judicial officers, managerial employees, supervisory employees, confidential employees, law clerks, attorneys are exempt from the collective bargaining unit. And Section 5 purports to strike supervisory employees from the list of exempt employees. And when we learned of that, this bill came out shortly before, crossover in Senate Economic Development Committee. And we asked for the opportunity to testify in order to voice our opposition to removing supervisory employees from the list of exempt employees. And Chair Clarkson indicated that their time was limited because of the crossover deadlines, and they had quite a few witnesses lined up because another part of the bill had to do with assistant attorneys general and their relationship vis-a-vis the bargaining unit. And she simply did not have time, so suggested we give our testimony when it came over to the House, assuming it passed over. So we did contact House Commerce initially, and then it went to House General and Housing to let them know that we did oppose it. As far as I know, there was not any testimony in depth in the Senate side before the vote was made on Section 5, other than the walkthrough. There was some question that came up in House General and Housing whether there had been testimony, and some representation made that there was no opposition to it. And we just wanted to clarify that there was no opposition because we didn't have the opportunity because of the timing constraints to voice opposition. And as far as we know, there wasn't any testimony on Section 5 in the Senate side. So that was one point that we wanted to just clarify in our initial testimony. We also wanted to point out that there are just 4 supervisory employees in the judiciary. And it's true that in the executive branch, supervisory employees are not exempt, but we would submit that there's quite a difference in the management structure in the executive branch versus the judicial branch. For example, my understanding is that there are approximately 10,000 employees in the executive branch and approximately 1,200 supervisory employees in the executive branch. We have 400 employees in the judicial branch and 4 supervisory employees. There's a lot more management. It's a very different management structure in the executive branch versus the judicial branch.
Are those 4 employees involved in the negotiation with that?
In the negotiations with, I don't believe that any of the 4 supervisory employees are in the bargaining team, if that's the question that you're asking.
Well, do they negotiate with the judiciary and the rest of the other people? Which
They're on the management side. They are exempt from the collective bargaining unit.
and they actively participate in that?
Well, all of the management is involved in terms of the different issues that are presented. Attorney McNeil is very involved, more so than me, in the bargaining negotiations, so he can, I'm sure he'd be happy to address that. But they are exempt. They're on the list of exempt. They're considered management. So our question was with 4, was it logical or reasonable to have a separate contract, a separate bargaining unit for just the 4 employees? We also asked if there was a reason, if there was a concern or an issue, because right now the collective bargaining agreement for non-management is very similar to our personnel policy that covers management employees, whether it has to do with benefits, the health plan, due process rights, et cetera. Typically, whatever the percentage increase is, for example, for non-management, is carried over to management. There's very strong similarities between the 2 documents that govern And so that was the other question that we had. I had at the time of the initial testimony spoken with one of the 4 supervisors to ask, was there an issue that prompted this? That person wasn't even aware of the proposed amendment, had not requested it, did not support it. Since then, I spoke with the other 3 and it was the same thing. They weren't aware of it, they hadn't requested it, nor did they support it. So we wanted to, first of all, explain that there were the 4, because I know in the Senate side, they weren't aware that there were just 4 supervisory employees. So we wanted to clarify that, and to clarify that, at least from what information I was told, it wasn't requested from the supervisory employees, and also to draw the distinction between the executive branch with the supervisory employee distinction and the judicial branch and the different layers of management, and ours being a much smaller, where our supervisors are involved, much more involved in managerial decision-making versus the much larger executive branch framework. We then learned, and this was in the testimony in the first round, if you will, that it was not VSE's intent to limit this proposed amendment to just the 4 supervisory employees, but their plan was to include the 24 court operations managers in the potential inclusion in the collective bargaining unit, by apparently planning to argue before the Vermont Labor Relations Board that court operations managers are supervisory employees and not managerial employees, to which we would very strenuously, vociferously object. Our court operations managers are the heads of each division. If you're familiar, remember from legislator day visits in the courthouses, the court operations manager is responsible for the day-to-day operation of their division, if not their courthouse. In the smaller counties where there's one courthouse, you could have one court operations manager who oversees the criminal, family, civil, and probate divisions. They're responsible for all 4 divisions where you have a court operations manager in one courthouse. In the larger courthouses, for example, in Costello, you have a separate court operations manager for the criminal division. You have a separate court operations manager for the family division, but they're responsible for that division. And the definition of managerial employee in the statute is an individual as determined by the board who functions as the head of a department, institution, district operation, or a major program or division or section. And that is exactly the role that the court operations manager plays in the judiciary. They are the head of the division, whether it's the criminal division, if it's a larger courthouse, or all of the divisions in a courthouse. And as you may recall as well, there's 14 units corresponding to the 14 counties. Each unit has 4 divisions: civil, criminal, family, probate. And the court operations manager, there are 24 of them. Again, some in the larger counties per division versus multiple divisions. And they function as the head of their respective divisions. And in the memo, I basically quote verbatim from the standard job description for these court operations manager. And to us, it's crystal clear they are managerial employees. The court operations manager will have responsibility for daily supervision of unit division staff within one or multiple divisions of the unit. The position requires managerial, administrative, financial, budgeting, and public relations work, including responsibility for planning, organizing, staffing, coordinating, directing, and evaluating the functions of the division. Clearly managerial. Minimum requirements: 4 years of management experience in a public or private organization. Preferred qualifications: a thorough knowledge of the management of the courts and casework techniques. The summary of duties which are laid out, I won't repeat all of them, but it's very clear that the court operations manager position is a managerial position. They're responsible for implementing the policies and directives of the Vermont Supreme Court. Extensive interaction with the presiding judge. Each court operation manager works closely with the presiding judge to oversee the management of that particular unit, that particular courthouse. There's considerable latitude for the exercise of independent judgment and initiative. They have oversight of cash management, review and approval of invoices, review and approval of timesheets and expenses. They coordinate the scheduling of court resources, the complex coordination, including courtrooms, employee work hours and breaks, law enforcement availability, judge time, court equipment. They manage the contracts. They serve on special judicial teams and committees to accomplish judiciary-wide projects. And this is all taken from the standard job description. It's nothing that's geared to this particular testimony. They also recruit, train, assess, supervise the workforce, and ensure the maintenance of all the court records and court documents. So we spell that out to show that from our perspective, and indeed from the court operations manager's perspective, they are management employees. I also asked all of the court operations managers to convene. 20 of the 24 were available. One was training, one was out sick. But I wanted to let them know that this was being proposed. They were not aware that it was being proposed, nor had they requested that it be proposed. And they indicated they weren't objected to it. Understandably upset that they, court operations managers, would be characterized as something other than managerial employees. They were flabbergasted to say, why would we not be considered managerial employees? And they brought to mind a point, or they made the point as well, if this is something that if it passes and we're going to be categorized as supervisory employees and there's a Vermont Labor Relations Board process to determine that, that is going to very much hinder and impede our ability to serve as managers and to fulfill our responsibilities. They have a very challenging and day-to-day, very complex duties. And anything taking away from their trying to run the day-to-day operations where you've known and you've heard from your testimony the different circumstances that can arise, the different mini emergencies that can arise that they're responsible for addressing. Anytime having to spent to devote to proving that they are management, and Attorney McNeil can explain what the Vermont Labor Relations process is that's involved in this. They very much saw as an obstacle to them being able to fulfill their managerial responsibilities. And they strongly object to this process on that basis as well, let alone kind of the, as I mentioned, just the reaction to their management roles being questioned in this process.
For this, so this is kind of new territory. How I'm gathering this is that it seems like it was probably well-intended, have protections for these employees, but that it sounds like it wasn't necessarily coordinated with, I'm trying to see, so just say like this does move, what is the downside? Is it because it's going to require judiciary to do work to organize this? Is it going to kind of put teams against each other? I understand the piece of like people don't want to be categorized as supervisor if it's not their type, that piece, but I'm trying to understand the on the ground, what is going to be the negative impact if this was to move forward?
Well, just to draw upon some of the comments that were made during the meeting, they said this looks like it's intended to drive a wedge between us and court staff, between us and the Supreme Court leadership. And there's something in labor relations law that's behind the whole reason why typically there's a demarcation between management and non-management, a division of loyalties. If they're disciplining an employee and they're part of a bargaining unit, even if it's a separate bargaining unit, it's the same union, where do their loyalties lie? How can the management enter into the normal candor that we have with our managers and our supervisors when it comes to contract negotiations, when it comes to back down to even basic disciplining? If it's somebody who is not, if you're going to say 100% loyal to management, which is what they are now, you have kind of different perspectives, management and labor. I'm on an advisory panel that submits applicants to the governor for Vermont Labor Relations Board positions. The Vermont Labor Relations Board has 6 members, 2 management, 2 labor, and 2 neutral. That's because there are different perspectives. There's the labor perspective and the management perspective. And if you expect court operations managers to function in a management role, I mean, irrespective of what ultimately comes out, they're in a management role and they're expected to play both sides of the fence. It just makes it very difficult. Operationally, I think it would be very difficult, especially when you look at the numbers, very small. So the 24 court operations managers say that they go through this process and the Vermont Labor Relations Board says, oh, no, they're not managerial. That's a third of our management force that we're left with our hands tied, if you will.
Because there's no union representation in judiciary right now. Is that what?
There isn't, the non-management employees are all part of the union, 240 odd.
And so
Which
this is segmenting part of the other part of it.
This is taking what we're considering a portion of management and taking them away from the management side of the equation.
Okay. And then the other question I had was around, so had asked current employees if they are supportive of this, which I can appreciate, but it seems like those aren't always the people that are going to be there forever, though. So I don't know if in other times has there been interest in this, and it's just these current employees are not interested, but there has been before, or.
From what I understand from talking with them, none of them said they were interested. None of them said that they requested it. None of them said that they supported it. The 4 supervisors and the 20 court operations managers. Attorney McNeil, do you know whether this has ever been attempted in the past?
If you could identify yourself for the record too, Joe.
Yes, Joseph McNeil, Lenny and Sheehan, counsel for the Judiciary and Labor Relations Matters. And also since 1990, the chief negotiator for the executive branches work. So to the best of my knowledge, Mr. Chairman and committee members, there has not been previously an interest expressed by managers or supervisors in the judiciary to be a member of the bargaining unit. I was involved with the initial creation of JELRA when it was first passed. In that law, both supervisors and managers were excluded from representation. And to the best of my knowledge, historically, I'm not there every day, but there has been no effort to organize either up until now.
So if I can ask a follow-up question to you as well, Joe. So if these individuals, the 20 managers and 4 supervisors, don't want to organize and be part of the bargaining unit, they don't have to, right? I mean, there's a process that would have to happen, and I would assume the way it would play out, and tell me if I'm wrong about this, that if they decide that they want to organize, that would be what would lead to a VLRB hearing on whether a manager is a supervisor or a manager. I mean, it's not like the SEA can, absent those individuals seeking to organize, they can't go to VLRB and say, we want these people to be deemed supervisors, or can they? It wouldn't seem like there'd be standing or.
Good question, Mr. Chairman. The answer is this, that up until just a couple of years ago, the standard was 30% of the proposed bargaining unit would have to sign authorization cards. And the labor board would verify the existence or the veracity of those cards. And thereupon, if there was at least a 30% showing, they would order a secret ballot election called a consent election or contested election, but a secret ballot election. And on that election, the union would need to receive 50% plus 1 in order to be a majority and certified as a bargaining unit. In the last couple of years, the General Assembly amended that procedure so that now, upon a showing of 50% plus 1 or 51%, the labor board can, without a consent election, without a secret ballot election, certify the unit as certified to represent that cadre of employees. You are also correct that before that certification would occur, as a matter of the first iteration, the labor board would inform the employer that there had been a petition filed, and the employer would have the right to challenge the appropriateness of the proposed unit. And historically, those challenges would come from either the employees are confidential and should be excluded by statute, or supervisory and should be excluded by statute in the case of JELRA. Also, as was mentioned, or a question was asked about other comparative statutes. Under the Municipal Employees Labor Relations Act in Vermont, both managers and supervisors are excluded. And under the National Labor Relations Act, supervisory employees and managers are excluded from representation. And the reason for that exclusion goes back to, believe it or not, 1947, with the passage of the Taft-Hartley Act and the amendments thereto, where nationally labor organizations requested that Congress exclude supervisors because of the conflict of interest concern. That the question was, can you serve two masters? The labor unions on their part thought that the inclusion of supervisors would dilute their independence or dilute their independence. Managers thought, and companies agreed, because they believed that if you were a supervisor, you owed your undivided loyalty to the company, and creating two masters was an inherent conflict of interest. That was the original basis for the distinction. And that has carried through, for example, in your State Labor Relations Act, which covers employees in the private sector in Vermont that are not in interstate commerce, so not under the National Labor Relations Act. There is also an exclusion for supervisory employees. It is true that since the passage, I believe, of SELRA, the State Employees Labor Relations Act, there has been an allowance for supervisors to be in a separate and distinct bargaining unit on the executive branch side. But as Terry indicates, the makeup of the judiciary is quite a bit different than the makeup of the executive branch in terms of the number of supervisors and the, if you will, the leanness and meanness of the operation in terms of the supervisory and managerial functions performed. But that's the background.
So one other question, follow up, and then, so to back up a little bit, if they have the petition, they go through this process, the individuals, then the LRB notifies the employer, and then they can object and say, these folks are, I mean, if this law were to pass and they were trying to get the managers to organize, they would say, well, these folks are managers and not supervisors. That's where that argument would come out into the LRB. Is that right?
You're correct, Mr. Chairman. What would happen is that the employer would be notified, the employer would have opportunity to object on the appropriateness of the unit. And let's say the bill passed and the SEA was taking the position that the employees are supervisory but not managerial. And the judiciary was taking the position, no, they're definitely managerial. That would then become a matter of a contested hearing before the Labor Relations Board. And if I could offer what I was going to offer.
Yeah, well, I'm kind of curious how good your argument is if it ever got to that.
You yourself would be able to test it very well based on your experience. True. But the part of the concern of the judiciary here is that in testimony, both before the House by the General Affairs and Housing Committee, by the SEA and by the judiciary, and as a matter of common knowledge across the labor relations sector in Vermont right now, we have a critical problem with regard to the decision-making of the Vermont Labor Relations Board. It has slowed down to a trickle. It has taken excessively long, and the process has become unduly burdensome and potentially expensive. Decisions that relate to cases that have been pending more than a year in several cases have not been decided by the VLRB. So the worry on the part of the judiciary is, even if we are in contest about the managerial status of this cadre of employees, the port operations managers, there will be disruption for a period of months in terms of whether they are, an expression, fish or fowl, managerial or simply supervisory, that will impact the operations of the judiciary, in the opinion of management, quite severely. So that is a problem that we're hoping the judiciary is hoping it doesn't have to face. I should add that an example of the concern about the VLRB was manifested in the most recent round of executive branch bargaining. And in that most recent round, the SEA requested, and the executive branch ultimately agreed, that with regard to grievances and with regard to impasse procedures, the VLRB would no longer be the forum of first resort. The forum of first resort became private arbitration panels, and only if both parties agreed to use the VLRB would that be the resolution panel. That is diametrically opposed to the history of the VLRB in terms of dispute resolution methodology in Vermont. And as I said, it went from the LRB being the matter of first resort, the forum of first resort, to the forum of last resort for impasse procedures and for for that.
So what's the downside of the court operations of that, other than the timing and the uncertainty that?
I think the downside, number one, is as I understand it, the concern across Vermont has been that the judiciary is backed up in its case decision process, is backed up and understaffed with regard to all of the work that it needs to do. And to add this additional complication, time, and expense to their already burdened operation seems unnecessary. If there is to be, judicial economy, to use that term. Number two, if indeed they are, as the judiciary represents to you, managerial employees, why does it need to go through this protracted potential process to prove what it already knows? And number three, it's a bit anomalous in Vermont to have supervisors included. Yes, true, as represented under SELRA, but not true under the Municipal Act, not true under the State Labor Relations Act, and not true under the National Labor Relations Act for good and sufficient purpose. So that's I may have missed something, but that's the basis of our argument.
Other questions for either Terry or for Barbara, then Karen?
So I
Ken, do you have a question?
don't know a ton about unions, but I was under the impression that even asking employees if they asked for a union is seen as a way of interfering on some level. And so my question is, given that everybody said no, I'm wondering if people perhaps didn't feel comfortable saying that they had been involved, and either way, is it okay to ask employees?
Yeah, I checked with Attorney McNeil because my background isn't in labor law either, but he can answer what he told me.
It is true, Representative, that from the time that a petition is filed, the status quo has to be maintained. And it would be inappropriate to attempt to influence one way or the other the decision-making of an individual who might be in the bargain. That standard of, if you will, forbearance begins with the filing of a petition. Here, there's been no petition filed. There's been no change in the law. We're debating a legislative matter at the moment. So my belief and what I communicated to the judiciary is that it is not, under those circumstances, impermissible to inquire of the employees, to ask the employees in one of their meetings, the managers, whether indeed they supported the legislation and were approached about expressing a view on the legislation. If the bill passed and the question of organization occurred, you're absolutely right. It would be impermissible at that point to interfere in the free choice.
And my primary concern was, is there an issue? Is there a problem? And if someone wanted to.
And I'm like, I get that you were coming from a caring place. I just worry that having been sort of trained a little bit when there might have been possible union activity, like that, doing anything that looks like it might have the appearance or effect of tampering down organizing could.
Right.
Yeah.
And in all honesty, too, when I learned that none of the 4 supervisory employees were even aware, my question was, and I was asked, do they support this? Did they ask for it? That was, to me, the only way to kind of.
Right. Well, it's funny that someone would, right, like they put you in a funny position by asking you that question. You feel like, yeah.
But that was the response, and it wasn't a mandatory, wording, but and to be, as I said, I was also the degree to which they reacted.
Right.
The idea was, not necessarily anticipated by me, but they did ask me to relay their views. So.
And being able to ask people if they have concerns, obviously, is always a good thing to do. Tying it to the union part just made me a little nervous.
Right. And we had just done an extensive workplace engagement survey. That's what I guess it's now called. With that, we got tons of great information and developed action steps to respond to the improved communication, enhanced training, and opportunities for feedback. We'd kind of done that fairly recently, and we're feeling everybody was kind of very positive. And so that was why I thought, oh my gosh, is there something that we're not aware of that we need to address? So that's the background to it. But I did, to your point, check with Attorney McNeil.
Yeah.
I didn't know, is that allowed or not? And he said, at this point it is.
And is it possible that it's related to salary and benefits and not necessarily workplace environment?
I don't know, because nobody indicated that they had requested.
Right.
And it's, to further answer your question, it of course is possible that somebody would say one thing to one group and another to another. We don't know that. But one point that might be made is that since JELRA was established and since the bargaining occurred with non-managerial employees, the level of increase that has been negotiated at the union level has been applied not to the judicial officers, you determine that by statute, but managerial and supervisory employees in the judiciary have all received the same.
Otherwise, the compression issue.
So there's no differential in terms of pay. There may be, who knows, some view that, they're not paid sufficiently by comparison to their counterparts in New York or Connecticut or whatever,
Right.
but they are with regard to the level of increases in the executive branch and the executive branch, the judicial branch, and the judicial managers and supervisors have all received the same level of increase.
Karen and then Ken. And then you.
Yeah, so appreciating this conversation and finding it tricky because I tend to support the right to organize. I certainly appreciate the work of the judiciary and understand the challenges that are there. So I'm trying to put these things together. And I guess for me, it is really trying to understand the impact because as I'm hearing this, to me, it sounds like it's just creating a door. It's like, here's the door. And it sounds like maybe folks won't open it right now. Maybe there's not a need or an interest to it, but that we're creating that space for the door. But maybe down the road, folks do want to, and that there's many steps along the way to get there. And so wondering if you can maybe share more about the impact of this. I'm hearing that there would be frustration or there would be this period of limbo. If the door was opened, and somebody went through it, we'd have to decide, are these managers or supervisors? But I'm trying to understand what is more of the impact than kind of frustration and maybe some confusion as you navigate folks through the process.
Right. Well, I'm just kind of repeating the expressions from the managers themselves, just saying that this would create a rift, drive a wedge, kind of call into question their dedication to their management roles. In terms of like an unnecessary, especially, I don't know, one that was not initiated by them. And to be honest, I would need to ask Attorney McNeil, if this did not pass, for example, and things were status quo, would not supervisory employees or managerial employees have the option to go through those steps that you were talking about?
It would be different if the bill did not pass. The supervisors and the managers would be excluded, as is the case currently. And if there were to be a petition filed, an objection could be raised on the basis they're supervisors. If the bill passed, an objection could not be raised on the basis that they're supervisory, only that they're managerial. That would be distinction. And in further answer to your question, if I may take a shot at it, that it really comes down to the inherent conflict of interest between truly managerial or supervisory employees in the case of the National Labor Relations Act. But assume this passed, it would come down to the viewpoint that managerial employees have one employer. They're hired for the purpose of advancing the best interest of the judiciary. Yes, they're hired on the basis of wages and hours and, stated working conditions, but their loyalty needs to run to the employer. That's what a manager does. And there's a whole segment of managers, for example, in the executive branch that are excluded because, for example, they're second chiefs, just as the court operations managers are at the very least section chiefs. But the notion is that the judiciary has the right to expect their undivided loyalty. And to repeat the example that Terry gave in her testimony, if the court operations manager is unhappy with the performance of a particular employee who's represented by the bargaining unit, especially if it's the same bargaining unit, even though it's a different unit within that bargaining unit. Or a different unit within the same union. It's going to be significantly more difficult. Hypothetically, some individuals will not have that problem, others will have it in spades of disciplining a colleague of the same union than would be the case if they're operating with loyalty strictly to the employer. That's the essence of the.
Okay.
Is Joe gonna be in the witness stand? Or is he doing everything over there?
It's not.
I'm happy to go there and raise my hand.
Well, I don't know if
Terry may have more, so we
Yeah.
kinda got sidetracked.
So
Terry, did you-
that's,
Well, mainly just to kind of explain the evolution, I guess, if you will, of our position and the reasons that we've been asked to relay. And we appreciate you and the Judiciary Committee being the most familiar with the judiciary. And for example, even knowing what a court operations manager is, which, is not the case in other committees. The other thing that our hope is that Section 5 would be stricken for, again, the reasons, if it's limited to 4 supervisory, the reasons why when we have just the 4 and no request for it, and the distinction of the whole reason is, well, the executive branch has their supervisory, when we can point to the vast differences between the management structure in the executive branch and the management structure in the judicial branch. What would be the purpose? But then to find out that this is a way to try to also encompass our court operations managers. That's why we appreciate you all listening, feeling that you would have an understanding about the impact on the judiciary. The other question I would have is whether or not, because there would be an impact on operations, and court operations managers asked if they could testify, whether or not it should also go to House Government Operations, because it does impact the operations, and they would like to explain why it is that this would be very detrimental to them. So that would be the other, I guess, request. One, we would strongly support striking Section 5 with that one word change, or asking for the opportunity to have government operations look at what effect is this going to have on operations, because certainly the court operations managers felt it was going to have a very substantial and severe detrimental impact on their ability to do their jobs.
go on, yeah. Let me just ask this one question. Not everyone that works in state government, and one of my questions coming up is, apparently to me, there seems to be many different forms of unions that side in with state government in Vermont.
And that would be, Joe, Attorney
Okay.
McNeil's purview. That was basically, the memos include points I was trying to relay on the basis of input from the supervisors and from the court operations managers.
I think I'll just wait.
Yeah, or do you have a question for Terry?
Thank
We're
you,
gonna
Terry.
have Joel officially.
Thank you, Terry.
Yeah, I think my question is for Terry before she steps down. And I think it's just understanding the process of how we got here, which is, I think, what you've been mostly testifying on. So I think the part that I'm confused at, and this actually might bring Ledge Counsel into. So if the goal was to have this be around court operations managers, why didn't the proposed language just strike managerial instead of supervisory? And is that because the model language or the language in the state doesn't have supervisory, but it has managerial?
My understanding is that nowhere would managerial employees be part of a collective bargaining unit.
Okay.
That's my understanding.
And so, and the statutory language that you provided to us in 3 VSA 1011 subsection 13 is the sort of judicial definition of a managerial staff. And
Yes.
your position would be that based on the court operation manager's
They are-
job descriptions, they are managerial
Yes,
staff.
they are head of the division,
Yeah, which is one of the
which is
defined.
verbatim from the
Verbatim.
definition.
Okay. That was the clarification I needed. Thank you.
Tom has questions.
I'm just trying to remember the whole hierarchy in the judiciary. Those 4 people are the managing groups of courts. Am I
The 4 supervisors,
Yeah.
they're actually, it's a disparate group, if you will. One is in an accounting department.
Oh.
Okay, two are actually court security. One you would know from the Costello courthouse, and the other is having to do more with the statewide to ensure that if there's a need in Wyndham County, that somebody can go and fill in so they don't have to cancel the jury trial. They disperse the more the statewide court security officers who fill in if need be, if somebody calls in sick or if there's a need for extra security personnel. And the fourth one is actually in the IT department having to do with help desk. So those are the four supervisors.
Getting those for it.
Okay.
Uh,
Oh, the code operations managers.
Well, yeah, I'm looking at, so you have the court operations manager and you have like a
There are regional
one tier
superior,
above that.
the regional superior court clerks who typically have 3 units or 3 counties. And they would work closely with the court operations managers, but the court operations managers are the one on the ground, on site at the courthouse, overseeing those day-to-day operations, the management of the courthouse, day-to-day. The regional ones might go from one to the other or oversee.
Are those regional ones, are they within the BFTA?
No, because they're management.
And then the court operations managers, they're not in the BFTA?
No. Neither are the supervisors. The 4 supervisory employees.
What? Trying to visualize who they would be.
The 240, say judicial assistants, for example, in the courts are part of the collective bargaining unit. They're non-management. So they're part of the collective bargaining unit. And then our other divisions, trial court operations is the courthouses. We have finance and administration, planning and court services, guardians ad litem, court interpreters, that kind of support. And then the tech department. So they also have, if you're non-management, 240 approximately, non-management, collective bargaining union members.
How long have the unions been involved with the courts, with the judiciary?
Trying to know that.
My recollection of the judiciary is slightly after 1990. Before that, the judiciary was not, there was no job.
So now you're still sitting there, which is fine. No, I don't mean it like that, but I'm just trying to like decipher all this stuff in my head. Like now, like judiciary, I mean, the unions are trying to become more prominent in the judicial end of this.
Yes, this is about the opportunity being afforded to the BSEA, or it could be another union as well. But it is the opportunity for a union to represent in a bargaining unit supervisory employees of the judiciary, which currently now is illegal. That's what Section 5 is about.
I'm gonna wait till you're there.
Okay.
Thank you.
Any more
Thanks,
questions for
Eric.
Terry? And then we'll have Joe become official and go into the hot seat.
Okay, great. Which,
Because I can't go past having Joe here as officially in the witness chair. I mean,
No.
it's,
We can't do that.
No.
I will happily Neil and follow Representative Gosson's wishes.
No, it's not my wishes. It's just, I'm just like
No.
trying to figure this.
Yeah, he definitely has a lot more answers to labor relations questions than I would.
So I hope we have more questions for him since we made Joe.
Oh, there you go.
Over here, so I can get.
I promise to give the whole truth and nothing but the truth.
I've been wanting to swear people. No, not swear at people, to put people under oath for the longest time. So thank you for giving me.
You're welcome, Mr. Chairman. If I could begin, most of what I wanted to cover has been covered in the questions, and I'll take questions from you. But Representative asked a question about whether the 4 supervisors were involved in collective bargaining. And I think that requires an answer that says that under both current law and projected law, or projected, if this bill passed, regardless, confidential employees would be excluded. Confidential employees are defined to be those who have knowledge of the collective bargaining process in a manner that would be incompatible with their official duties. So while it is possible that those four individuals have contributed to the judiciary position in collective bargaining, I could represent that they're not typically a part of the management team that has bargained these contracts in the past. I don't think they would qualify as confidential employees under the current definition. So the only way that these employees, to the best of my knowledge, would be excluded is under the current law as supervisors, the four of them, or with regard to the managerial employees, the COMs or court operations managers, that regardless of whether this passed or not, though we would prefer that it not pass, we would be able to maintain before the labor board that they are managerial in nature.
Okay.
Representative, I'm totally confusing you and I apologize.
Don't apologize. I think this is new to all of us. How many different unions are there
In state government.
in state government?
So the VSEA is the primary actor on the union side in state government, and it represents currently the employees in the executive branch in three units.
The executive branch of what?
The executive branch of the state of Vermont under the jurisdiction of the governor. So there is the non-management group that is, as it says, non-managerial employees across state government. There's about 6,000, I believe. Steve can correct it if it's off by a bit, but essentially there's 8,000 in all. There's like 6,000 in the non-management unit. There is the corrections unit, which is the non-supervisory employees in corrections. And there is the supervisory unit, which includes supervisors across the executive branch. So if, for example, you're talking about a state police lieutenant, state or a supervisor in Parks and Rec, those employees under the executive branch are in a separate unit called the supervisory unit. There is also an additional unit in state government called the Troopers Association. The state troopers in the state Department of Public Safety and Department of State Police, they are in a separate and distinct bargaining unit from the SEA. It's an independent association. The SEA also represents the non-managerial employees of the judiciary, and it represents the non-managerial employees of the state colleges. And that's, represent the Defender General. Do you represent the Defender General now?
We do, and of course, one of our more important units is the state transport deputy.
Oh, yeah, of recent legislative activity is the state transport deputies. And also, I forgot to mention, the state's attorneys and sheriffs are also represented by the non-supervisory employees of the state's attorneys and sheriff's department. The deputy state's attorneys, for example, are represented by VSEA.
We have a lot of the different unions.
You do.
And represented by the state. So let me ask you this. I thought it was my understanding that a state employee did not have to belong to a union.
That is definitely true under the so-called, well, the answer is yes. They also do not have to pay dues or a dues equivalent as a result of a United States Supreme Court decision in Janus, called the Janus decision, that applied to public sector employees across the nation. So whereas there used to be in the public sector either membership or membership equivalent in the form of what's called an agency fee, that doesn't exist anymore in the public sector. In the private sector in Vermont and elsewhere, there can still be union shop clauses, which means that an employee must either be a member at the time they're employed or become a member within a certain period of time thereafter. That was not affected by Janus, but in the public sector it was.
Yep.
So there's many, like the teachers union is much more powerful. They have many more benefits than what a regular employee would have, correct?
I doubt Steve would agree that the teachers union is more powerful than the SEA, but it is true that they are a significant labor presence in Vermont. They represent, for the most part, teachers and support employees in school districts throughout the state.
They have much better benefits.
There is an argument that they have better health insurance as a result of the creation of the statewide commission and the determinations which have taken place there. Again, I don't want to get into an intramural thing between the BSEA and the Vermont NEA. I deal with both of them, and
I thought you were a lawyer, not a politician.
I'm a negotiator in that sense.
That's what I'm trying to be.
Okay, then let's go.
I think we ought to have them all meet out here on the front lawn there and they all discuss stuff. So going back, I believe a couple of years ago, there was discussions, and I don't think it went anywhere, but new employees to try to get more people involved, or there was something,
Yes.
there was something that was said that basically instead of which I guess you've already answered, you would be hired under a different stipulation than what an existing employee already had for their benefits and stuff like this. Because when the last negotiation, I think, was going on, I didn't think it was fair at all. If you were hired under one level and one stipulation that benefits were going to be this, that was to stay that way. And then new employees coming on or something could be looked at differently as part of a negotiation thing.
Okay, so as part of a typical negotiations round, and this would not be impacted by the legislation either way, because whether this passes or doesn't pass, it'd still be negotiating wages, hours, and working conditions. But one of the working conditions that is typically negotiated is the so-called market adjustment factor, which relates to recruitment and retention of new employees and the impact on existing employees. That's something we talk about in bargaining frequently, and there are existing agreements as to that in, I believe, all or nearly all of the collective bargaining agreements in Vermont. I think what you're talking about legislatively is the bill that was passed a couple years ago that added hard check to the certification process, which I spoke about earlier, that previously required showing of 30% first and then a secret ballot election of 50% plus one. And it metamorphosized or changed into where the labor board could certify a bargaining unit, an appropriate bargaining unit on 51% hard check. In other words, they would review the authorization cards that were submitted, and if a sufficient majority was found to have submitted those cards, they wouldn't need to have an election. They could just certify the group as part of a bargaining unit or a new bargaining unit.
So am I wrong to think that unions were kind of fading away a little bit years ago, and now they're coming back stronger than ever?
I'm not going to sing the Marseillaise today, but I would
I don't even
say
know what that word means.
I would say you're right as it related to the private sector in particular, that there was a significant diminution of union participation, union membership across the United States in the private sector over several decades, which seems to be reversing right now. In my experience, in the public sector, which I have had the privilege or the burden of dealing with since approximately 1970, not to age myself. The public sector unions have only gained in membership and diversity and, very frankly, bargaining authority, bargaining strength over those years. More and more people are in the public sector, more and more are organized into unions, and we have significant bargaining.
So just to be clear, in my real life, I deal with unions all the time in the granite industry.
I'm sorry.
No, I love it. I love to negotiate. It's fun. So, I just lost my train of thought.
Oh, I'm sorry. I
It
didn't.
wasn't your fault.
You were talking about the granite industry and how you've dealt with them all.
Yeah, but, damn it.
I can jump to Tom and come back to you. You got it? Yeah.
So did I hear earlier that now in Vermont, we're trying to get to the national level of what labor, what union people are being paid? Are we trying to do that now in Vermont?
He would be a better person to answer that than I in terms of what the union motivation is.
I think
I would just answer in the words of George Meany, who used to be head of the AFL-CIO. He was asked that question, what does labor want? And the answer is more.
Really? Shocking.
That was his answer.
Yeah. Yeah.
But Steve would be a better person to answer that.
You know? Yeah. Okay.
Bear in mind that I don't come here as someone who is philosophically opposed to unionization or philosophically opposed to fair bargaining.
Right.
It has been a good career for me doing exactly that. And I think for the most part, the unions I've dealt with and the representatives of those unions have been fair, have been, aggressive, expectedly so. And, sometimes it's more often than not, it's resulted in negotiated agreements.
Mhm.
Sometimes it's not so, and it's resulted in strikes that have not been pleasant.
Yeah.
But all in all, there's no philosophical objection to the process of bargaining. And I don't want the committee to think that that's our representation.
All right.
Our representation is simply that we believe that there has been good philosophical reasons for the exclusion of both supervisors and managers from the Judiciary Bargaining Act. We'd like that to continue, and we certainly would not want to see titles that we believe to be managerial included because of conflict of interest.
Actually, one more thing that I was involved in with unions that I forgot, when I was on the select board was the police union. And then we had to bring in the, what is it, the federal?
Mediation?
Federal mediation. Do we do that at the state level too?
Yes, historically, when and if impasse has been reached, then the first level of impasse resolution procedures are called mediation.
Okay.
And mediation is a process by which a facilitator comes in.
From the feds?
Usually from the feds. It doesn't have to be. But there is a story connected with that is very topical, unfortunately. The president, the current president of the United States, has effectuated layoffs of all federal mediators in the country, with the exception of 3 or 4. The two offices that serve Vermont from the Federal Mediation and Conciliation Service were out of Albany, New York, and Portland, Maine. Those mediators have all been laid off. So unfortunately for this state, a free service, which both we and the union side of the equation have had from the federal government, is now no longer available to us. So mediation will become more expensive than it has been in the past.
Thank you. Just trying to understand all of this stuff. I appreciate that.
The impasse procedures that we go through when you can't reach an agreement are first mediation, and then a process called fact finding, which presents evidence but gets a recommendation, not an order. And the final step is final and binding arbitration, which gets an order that is binding.
Thank you.
Tom.
Thank you. All right, let's take the gloves off now, right? No. We negotiated that, I think. Our first contract, it was pretty fun. It was actually a good time. No, so.
They are.
Yeah. I understand the concerns about management, maybe not wanting to cross over into the union. I don't know if that's a manageable thing or not. I don't know of enough experience with unions. What I do worry about a little bit with this, and I'm not implicating anything, only that, and you can answer. I think when we started to get into the union, we tried getting into the union for 10 or 15 years. And I could never understand that we had to come in here and legislate it through. And that was always where we stalled every single time. And I don't know why we haven't figured out how we could do that without having to come here every time some group of employees want to unionize. We haven't figured out what the structures are and who can and who can't. There are groups out there that are still not in the union that I'm aware of. And it just seems like it would be easier to get it over with, I think, if someone.
So just a couple of reactions to that. If it's a private organization in interstate commerce, and proving that you're in interstate commerce is next to no burden at all, frankly. But then there can be a petition to the National Labor Relations Board for certification. And that's no Vermont legislation is necessary for that.
I'm just talking state employees. That's
Yeah.
the only thing. I mean, it seems to be we should be almost done. I think there can't be many groups left that don't have.
I don't believe there are, frankly. And I know that, the transport deputies were the most recent, the state's attorneys and sheriffs prior to that. But I'm not authorized to speak for the judiciary on its position about bargaining in general. Speaking personally, don't have any objection to any organization by non-managerial, non-supervisory type of employees because I have no inherent objection to collective bargaining. I've there are elements of it that, that I could speak to, particularly in the Teachers Act, that is irrelevant today. But the focus that we have today by the judiciary is more narrow, distinctly more narrow. We believe it has been a good feature, given the size and operations of the judiciary, that both supervisory and managerial employees have been excluded. We'd like to see that continue, all things being equal. Beyond that, we certainly would not like to see a position that we believe to be inherently managerial brought within the collective bargaining environment because of conflict of interest. And I don't know that I can be any more explicit about that.
Can a supervisory union be isolated enough that it insulates itself from?
In the executive branch, it has proven to be yes. But there are, in the executive branch, there are non-management employees, there are first level supervisors, there are managers, designated managers, there are deputy commissioners, there are commissioners, there are secretaries, and then there is the governor's office. At the judiciary, it's a much leaner operation. And so the four supervisors exercise a responsibility that the judiciary believes is much more in the nature of management than is the case with the first level of supervision at the executive branch. And consequently, its belief is that changing the existing law and allowing supervisory employees in the judiciary to organize and create their own bargaining unit, much less managerial employees, would have an unnecessarily adverse impact upon judicial operations. That's the essence of the argument. Thanks, Tom.
Had his hand raised. No, Angela, but
So I just want to ask you if my bottom line understanding is accurate for the purposes of this section of this bill. It's what I'm understanding is I understand the judiciary's position and why they feel this way. Is it fair to say as well, or is it accurate to say that if the change moves ahead and supervisory positions are no longer
Excluded.
And is there an assumption here that the managerial positions will also be excluded? Because they're not yet.
No, the reason for our comments relating to the managerial positions relates to testimony that Executive Director Howard gave before House General and Housing. And he indicated that should the bill pass, it was VSEA's intention to attempt to organize the court operations managers. That was the first that the judiciary became aware that employee positions other than the four positions which the judiciary had designated supervisory were at stake in this legislation. And that created a much greater level of concern on the part of judiciary management as to the potential impact of this proposed change.
Okay, so about that potential impact, if the change moves ahead, then and it turns out we understand that right now these particular employees are not interested in becoming union members. but that, if that door is open for them, future versions of them, people in these positions, there would still be another hurdle to.
Yes, there would have to be a petition submitted by at least 30% of the proposed bargaining unit as a threshold. It might be 51% to try to avoid a secret ballot election and get a card check certification. But there would have to be at least 30% that petition for representation by either VSEA or some other union. And once that occurred, in fairness, the labor board would notify the employer, and the employer would be given the opportunity to object to the appropriateness of the unit. The employer could say, if, for example, the effort was to organize the court operations managers, the judiciary would not be precluded from saying, these are managers, they should be excluded under law because there's no intent and there's nothing in the bill that would change the managerial exception. And the labor board would then have to make that determination after an administrative hearing. Okay. The point that we're making is not that that would be avoided or not that there wouldn't be a potential for that. That is all true.
Right. Is the concern that process would be disruptive? Yes,
the concern is twofold. Number one, the process in and of itself, the diversion of responsibility, the diversion of effort, the time and expense of litigating the issue of whether they are management or not management, that could take a prolonged period of time, particularly given the current level of decision-making by the BLRB, would be an unnecessary diversion of the time and effort of the judiciary when it has many more significant things it has to deal with, like court backlogs, et cetera. Then secondarily, the concern would be that if the labor board determined that the court operations managers were supervisory but not managerial, then that would adversely impact in the minds of the judiciary leadership, fundamentally, the judiciary's operation, because it would create a division of loyalty among people that are believed to be managers, are treated as managers currently, are involved in managerial decisions, and after being certified as being in a bargaining unit who will be bargaining collectively, concerted activity with respect to the judiciary on wages, hours, and working conditions, there will be an inevitable division of loyalty between their managerial responsibility and their union allegiance. And that's the concern.
Okay. So the fear in opening the door, because to me, opening the door is just that. And then, it's hard to say that that's a bad thing. But then what I'm hearing is that there's concern that the labor review board would handle this, would not agree with the judiciary's view of these positions, and that would cause real trouble.
Opening the door in the minds of the judiciary would be a bad thing if you were to philosophically take the view that it's okay for managerial level employees to be in a bargaining room. The judiciary believes, and I believe even the executive branch believes, that is incompatible, that dichotomy is incompatible.
Can I just clarify that we're not taking out the managerial part of it?
No, you're not.
But it's a misnomer. in
Yes.
this case, because the court operations managers are actually supervisor
The,
roles.
the,
So they-
the court operations managers in the eyes of the judiciary are both supervisors and managers. And while it is true that you would not be taking out the managerial distinction, you would be creating the possibility of protracted, administrative differences of opinion that would have to be litigated, on that question.
There's an irony. Litigating this. Anyway, okay.
May I
I think
one
I-
clarify?
But it would only be litigated if that was pursued. As of right now, there's nothing in here that would confirm the future that that is going to be pursued. Right
You're-
now,
you're-
it's the 4 people that are definitely.
Oh, no, I mean, if you, pass the bill, then very clearly the 4 supervisors would be eligible. But the Vermont VSEA has stated in public testimony that their intention is to attempt to organize the court operations managers. So while it is true that at least 30% of them would have to sign a petition to get the ball rolling, the judiciary has been officially alerted that that is the intent behind this proposed legislation, and that's why the ardor of its objection has increased.
Great.
I think that, yeah, the challenge for me on this, I think, is that if you are someone who fundamentally supports workers' rights, then you have to oppose this out of fear that the Labor Review Board would see things very differently than the judiciary.
I think there is a difference between not opposing collective bargaining for the non-managerial supervisory class of employees, like has been traditionally the case under the National Labor Relations Act, and the determination to include supervisors who may be managers in the judiciary believes to be managers in a bargaining unit, because it is not inconsistent, I believe, with support for bargaining to believe that supervisory and managerial level employees have the type of conflict of interest that the Congress saw and has retained from the 1940s to the present.
Thank you.
Thanks.
All right, so I think we'll go to Steve Howard, and after Steve, we'll take a break before we move to S12. Just since we're all have our minds focused on this, let's hear from Steve. Thank you very much, Joe. And
Nice to see you.
yeah, I think Angela was gonna bring us.
For conditioning the air.
Somebody.
I was wondering, but it's gonna be loud enough this week.
You going home tonight so you can get it for us? So thank you for being here.
Thank you very much. And I know it's tough to be the witness between testimony and the break. And I apologize. So I hope you'll indulge me while I try to go through the testimony. And Mr. Chairman, I'm here with Tom Abdelnour, who is our legislative coordinator at VSEA, and probably the only union member here. He's a member of the VSEA Staff Alliance. This is our former retiree, a former unit chair at VSEA, but so I may just as my friends in the judiciary have refer to Tom on some issues, if that's okay with you.
Yeah, absolutely. And identify yourself for the record as well. So
Sure. I'm Steve Howard. I'm the executive director of the Vermont State Employees Association. We represent the frontline workers in the judiciary. There are about 200 folks, the docket clerks, the folks who provide court security, the people who do the hands-on public-facing work in the judiciary. They're not usually back in the offices. They're up in front at the counter. They're in the courtrooms. They're at the doors. And they are the frontline workers who make the judiciary work. And I know it's a rare opportunity to be in judiciary to testify on a labor bill. which is one that I really welcome because I don't think this is my first opportunity to be in here, and I can't go further, Mr. Chairman, without recognizing the amount of Rutland County energy that is in the room here today.
But you used to live in my district.
I used to live in your district. Yes, that's correct. That is
Really have Rutland County power when Chief Justice Reiber is in.
Yes, yes, as it should be, as it should be. Mr. Chairman, this legislation is among VSEA's top priority this year. And it's among our top priority, one of the important labor bills of the session, because our members on the front lines who work with folks who are supervising have had great conversations with those supervisors. And they have been asked by those supervisors for help. We have, as you all are painfully aware, experiencing a massive backlog in the judiciary. That falls mostly on the shoulders of our members and on the shoulders of the supervisors. We're also working in an environment that is very difficult for labor. It is what our members would describe as an anti-labor environment. So when I describe that, I would say, I know that you heard Mr. McNeil refer to wanting to bargain, but very rarely do we ever bargain on a schedule that our members would like. In fact, the judiciary tries to delay it as long as they can to the very last minute. So this is a really important thing because our members have had great conversations with frontline supervisors who have asked the VSEA for help. That's why we're here. Now you'll find, and I think you probably understand this, I think Representative Rachelson referred to this. Frontline workers will not often tell managers what they really believe for fear of retaliation and retribution. And that is something that our members identify as a major issue in the judiciary today. In fact, we had a manager in the judiciary once refer to our members, compare our members to monkeys and say a monkey could do your job. And in an insulting manner to workers in McDonald's, said I could go find somebody who works at McDonald's to do your job. And these are the folks who are in the front lines of the courtroom. These are folks, mostly women, who are running the courtrooms. And that's the environment in which our members operate. That's why we're here today. This bill's about one thing. I know you heard quite a bit of testimony about the details. It's about one thing. Do you believe that these folks in the bargaining unit that will be determined by the Vermont Labor Relations Board have a right to vote yes or no on whether they want to be in a union?
Tell me which of these folks you're referring to, just to be specific.
So that's a really important thing because as the judiciary knows, the process for forming a bargaining unit involves the petition process that Mr. McNeil described. And what happens with that is the union, could be the VSEA, could be another union. We bring those signed cards to the Labor Relations Board. And that board, a quasi-judicial body made up of 2 managerial representatives, 2 independent representatives, and 2 labor representatives. They decide who's in the bargaining unit and who's not. Do that after a mediation process, and they do that after a hearing. It could take a day, maybe a day and a half. It's not hasn't traditionally been a hugely burdensome problem. And we're really grateful that the legislature has allocated additional resources to the labor board in the budget that this House adopted and the Senate has adopted. So that's going to be very helpful in helping the labor board move forward. One of the reasons why the labor board is behind, incidentally, is because they prioritize the constitutional rights of workers and they put elections ahead of all the other issues that are on their docket. And they've had a number of elections. I think Representative Gosselin referred to the growth in the number of folks who seek to be in a union. That has been true in Vermont. So there's more elections for the labor board to operate and to run, more of these hearings to have. And they have prioritized that. And that's why some of the decisions on grievances and unfair labor practices taken longer. Because members have a constitutional right of association, and the labor board rightly prioritizes that. So I think that's really important to acknowledge. So this is not something that's brand new that fell from the sky. The state of Vermont has 50 years of experience with supervisory unit. And I can tell you, having represented the supervisory unit, like our state police lieutenants, that they do not have any confusion about their loyalty to the state. When those state police lieutenants go out and put their lives on the line, they are protecting the public, and they're not thinking about whether they should be loyal to a union or loyal to the state. They are doing their jobs. And so it's rather insulting to say to them they would have a question about whether they are loyal to the union or loyal to the state. Our supervisors, who for 50 years have had their own bargaining unit, have shown time and time again their loyalty to the state of Vermont. And that has not been an issue that has confused anybody. Also, I think it's important to really make clear that the use of manager has been conflated with supervisor. There's a difference. Now, there are folks who have manager in their title in a bargaining unit in Vermont. So a reach-up case manager that I know Representative Rachelson is familiar with her work. Reach-up case managers have that name in their title. They are in the bargaining unit for the VSEA. They're in the non-management unit. So that is really important that we not conflate those two, and that we show that there is precedent, 50 years of precedent, but also precedent with the reach-up case managers.
So just a quick question on that one. It's not the label so much as what the responsibility is, though, right?
That's right.
Reach-up manager sounds quite different than what I'm hearing as far as managers, operations managers.
Right. So what the judiciary is actually asking you to do is to do the work of the labor board for them. Because the decision about whether somebody is a manager in the bargaining unit or not is a decision that the labor board would make. Now, maybe they think they're not going to be successful before the labor board, that will make stronger arguments. Maybe I don't know what their fear is about that, but that decision is a decision that has always been made by the Vermont Labor Relations Board. And that's what they're asking you to do, is to prevent our members from having prevent the folks who are in a potential unit from either signing a card or having a vote, and prevent the Labor Relations Board from exercising what has been traditionally their responsibility to determine whether somebody fits the decision, fits the category of a manager or someone in the bargaining unit. And they did that with the Vermont State Police lieutenants. There was an attempt by the management. Management never really wants people to be in the union. They try to discourage it as much as they can. And they did with the Vermont State Police lieutenants. And the labor board ruled, after doing a pretty substantial analysis, that those lieutenants were supervisors, but not managers. And they are in the supervisory unit that has existed for 50 years in state government without any problems, without any issues. So that I think is a really important issue, Mr. Chairman, that the labor board has in the past decided. And so we would welcome the opportunity to make a strong argument over the folks that we think should be in the bargaining unit. And we certainly would welcome the opportunity for the judiciary. They're in very good hands with Mr. McNeil. If I'd known they were going to bring out the big guns, I probably would ask Gary Hoadley to come join us, or someone who sits on the opposite side of Mr. McNeil. They can make very ferocious arguments on their behalf as to why someone doesn't belong in that unit. That is all, and has been traditionally done before the quasi-judicial independent labor board.
So just a comment on, I guess, or a question on that is, it seems that the legislature has in the past made decisions of who's exempt or not, and that has in the past exempted supervisory positions. So it doesn't have to defer to the labor board necessarily. Maybe the difference between supervisory and managerial, because they've certainly done that, but we have a decision, well, the legislature has a decision of whether to even open that door by putting that question before the LRB.
That is absolutely true, because the statute currently prohibits this group of supervisors, unlike their brothers and sisters in the executive branch, from having even a vote on whether they want to be in the union. So this is really about giving the supervisors in both branches the same rights. It's balancing out and providing equity between those two groups. So you're absolutely right about that, Mr. Chair. And so we would encourage you to support that. I will also say, because I spent months in the House, in both the Senate and in the House General Committee, hearing, testifying, and working on this bill. This bill has received in-depth testimony, in-depth debate. Now, I'm sorry if the judiciary missed that discussion, but the workers can say that they engaged in that discussion and engaged in that debate, and a significant amount of time by your colleagues was given to this bill. And I'm very pleased that your neighbors across the hall just took a straw poll and voted 9-1 in support of this provision. The Labor Committee has taken a lot of time and a lot of testimony and has a deep history of this kind of legislation coming before them. So we're gratified by that and very grateful that we had the opportunity to weigh in. I think what I would say before I take any questions that you might have is that this really isn't that confusing. As I said, this is really just about allowing these folks to decide if they want to have a vote. If the management, if Ms. Gorzones is right and it's not something they want to do, they can vote no. They can say they don't want to sign a card. But they'll do it without their supervisor or their manager sitting before them. They'll do it in private, and they'll do it in a way that allows them to be protected both by statute and by that privacy. So I think we're grateful for the opportunity to testify. I will also say, and they're not able to be here today, in addition to the support across the hall, the Vermont AFL-CIO has also made this a very important priority, because they too have heard, both from our members who work in the judiciary and the working conditions and the environment they work in, but they've heard from the supervisors who the management claims to speak for, about how important it is that they have an equal voice at the table, so that we can both address the working conditions, we can get through the backlog, but we can do it in a way that gives the workers the voice that they deserve and have earned. And with that, Mr. Chairman, I'm happy to take any questions. And of course, Mr. Abdelnour may correct or add or change anything that I might have said.
Mr. Chairman, with regard to that comment, I'll make only one quick clarification. Tom Abdelnour, for the record, legislative coordinator for VSCA. And that is to point out that although I appreciate Steve's recognition and his proper recognition to Representative Oliver for his time as a proud VSCA member, there is, in fact, I was reminded, one additional union member in the room with us today, and that is Representative Rachelson, who is a proud member of AFT Vermont.
Oh,
United Academics.
Yes.
United Academics. Wonderful.
Okay, I just want to make
My mistake. Thank you for correcting me. And I'm sure you are very loyal to the students who you teach, and also a member of the union.
And to be, my son is a member of the SEA union as well. So
Your son is very smart.
The member of a union.
well, there we go.
Good. So anybody else have children that would enjoy? Yes, here we go. Things are looking good.
Should we all sing this song?
Yes.
Yes. Solidarity forever, right?
Questions for Steve. Fairly straightforward, the position that you've given us, Steve, I understand. The questions? No questions. Okay. We'll take this under advisement and think about this a bit. So we just have Michelle left to go over S12. I've been in contact with her. She doesn't have a ton of time, but let's take a 10-minute break, and please do make it just 10